Welcome everybody. I just will say a few short words and thank our contributors and Dr. Iloka for organizing tonight's event. I'm just sitting on the sideline really, and I think as a host and assisting Uche, uh, and speaking as a layperson in a charity context. But I am aware, as you are, of just the almighty importance of charities in Scottish and British society today. Uh, they have been for centuries, as perhaps we'll hear, and they are today, and their importance perhaps even greater now than in the past through sort of the shrinking of the welfare state in the UK and corresponding increase in the roles and importance of the charity sector, and not only taking important or acting in important and crucial areas in society, but also uh, accepting money from donors, and hence both of those purposes lead to the importance of regulation and trust. And those are some of the subjects we'll be speaking about tonight in regard to the regulation of charities. So I want to pass now to my colleague, Dr. Iloka, who leads our charity module in the law school and previously was a solicitor in practice in the area. Uche.
Thank you so much, Paul, and thank you everyone for joining us this evening. So this evening is particularly interesting because it has an interesting mix of both current honors students in the charity law module and a number of participants from the wider, from outside of RGU. But you're all very much welcome, and I believe we would all enjoy this. We have an interesting lineup of experts in this, and why this is important is because charities are important. They actually make a significant difference in our society, and but the impact that it makes usually requires the hard work and commitment of thousands of actors who play different roles across in the charity, starting from the trustees to the CEO to the regulators to the volunteers that are really in the front line, and various other actors that play a significant role in how it works. But today, we would be looking at how these roles intersect in trying to meet the charities objectives. So basically you find that most of the people who set up these charities, they're driven by a heart for their causes, and as a result they tend to wear different hats because they don't usually have several enough resources to sort of deal with what they do. Sometimes the charities do so much more with so much less, and really for the most vulnerable in the society. And in a time where resources are depleting and their services are on the increase, it is important to understand how these roles, how these various actors in the field actually bring about some positive change to the society. I'm sure we're all familiar with the private sector or the public sector, but not quite so with the third sector. But the charity sector, which exists within that area, is one of the major drivers of the way the society works. So today we have people. Well, most of the experts also wear different hats, but they're in different capacities today. So we have a trustee, we have a CEO, we have key operational officers within a charity, so the in-house counsel, head of the legal team in a charity, and we have the external solicitor, and importantly, we also have someone who from the regulators, so the regulators to come and see. They would all discuss and have this chat. So the first question I would be given to talking about a regulator would be Steve Kent. I'm gonna pass on to Paul to start on with the questions, and then we'll carry on from that
Hey,
point.
I've been given that task and an easy question for me to ask in a starting one. Steve, if I could, hello, welcome. I wonder if you could tell us all what are the functions and powers of the Office of Scottish Charity Regulator?
Thank you very much, Paul, and good afternoon, everybody. It's a real pleasure to be here. I say good afternoon. At this time of year in Scotland, I'm never quite sure whether 5 o'clock is the afternoon or the evening. It's actually pitch dark outside, but I've not had my tea yet, so it's still the afternoon for me. And also welcome from what is actually the middle of National Trustee Week in Scotland. Let's not forget that this is the week when Scotland celebrates the tens of thousands of people that Uche was referring to, who are responsible for running charities in Scotland. And let's not forget in that the vast majority of charities in Scotland have no paid staff at all. They're run entirely by volunteers and entirely by trustees. The majority of Scottish charities are very small, in fact. The OSCR, the Scottish Charity Regulator, was established in 2006 in its present form, and its functions are set out in legislation. I'll refer to it as what the
Hi everyone, looks like we've got a bit of a freeze at the moment. Bear with us, we'll get this start back on.
Let's just give him a split second to see if his technology can debug. Oh, maybe he's coming back in.
Yeah, Steve is back now.
Okay.
Hi, Steve. You're on mute at a minute. We lost you for a bit. You're still on mute. You probably want to unmute yourself. We thought you dashed off to the Trustees Week.
Not quite sure what point you left me, but yeah. So I was explaining that OSCR was created in 2006 under legislation, and it's that piece of legislation, the 2005 Act that we derive all of our functions and our powers from. Broadly speaking, we have a dual function. We are a registrar and a regulator. So we have functions to do with the registration of bodies as charities and the maintenance of a public register of charities that anybody can search from our website. And we have to apply what's known in law as the charity test to applications to satisfy ourselves that bodies meet the test and warrant entry to the Scottish Charity Register. And once they're on the register, we then have a role to regulate them and to ensure that they comply with the provisions of the 2005 Act, and to investigate and take remedial action where we identify apparent misconduct in the administration of charities. And by misconduct, I mean where there has been some breach by the charity trustees of the general duties that they have under the legislation. The powers that we have broadly, I think, can be divided into two types. We have what I would call powers of inquiry. So we have powers to gather information and to share information with other bodies, to inform our decisions. So it's, that's where we build up our intelligence, if you like, about charities. And then we have powers of enforcement, which is where we have identified that some sort of regulatory supervision by us is needed, perhaps where we've identified misconduct, for example. The powers of enforcement that we have are, by and large, they're what I would call interdictory powers. They're preventative powers. They're there to protect charity assets. So in other words, we have powers to stop people from doing things. One of the areas that we're actually, a Scottish Government is consulting on at the moment, in fact, is whether we should have a power of positive direction, where we can actually direct charity trustees to take certain actions as opposed to just stopping them taking certain actions. Those powers of enforcement, we either exercise by ourselves, or we can apply to the court in some cases to for the exercise of those powers. So, for example, if the appointment of a judicial factor to a charity or the permanent disqualification of a charity trustee are not actions that we can take ourselves. They're ones that we need the court to do so.
Yeah, Steve, can I just so that you can this question I could ask you, I'm about to ask you, probably would answer it whilst discussing the powers as well. I was going to ask, so in relation to, you've been talking about the trustees, and it's really in relation to the concept of collective responsibility, who is actually responsible if things go wrong, and who's responsible, in terms of how the charities are really working, and at what point you as the regulator, you've talked about these powers, at what point do you then intervene in order to sustain or maintain the public's confidence in the charity and in the sector as a whole?
Yeah, good question. I mean, whenever we receive intelligence about charities, and which could come from a variety of sources. I mean, it might come from the public through complaints or concerns. It could come from other regulators sharing information with us. Excuse me. Very often it comes from charities themselves, who will notify us of things of concern within their charity, or things that we pick up through our own sort of routine monitoring of charities. Before intervening, we will carry out a risk assessment to determine, first of all, whether we have any locus to act at all. Just to be clear, our remit only extends to matters of charity law. A lot of it's something which I think concerns the public quite a lot. Often they will raise matters with us that are not actually matters of charity law. They're things to do with employment law, health and safety law, all kinds of things. So for the first thing we have to do is to say, well, actually, is there actually a matter of regulatory interest to us here? We will also take into account whether or not the trustees themselves appear to have got the matter in hand, whether they seem to be addressing the matter themselves. We don't run charities, trustees do. So, what we need to satisfy ourselves of is that the trustees are running the charity and managing the charity effectively.
Yeah.
By and large, we will only intervene where we believe that there is sort of deliberate reckless behavior on the part of the trustees, and where we believe the assets of the charity, or in some cases vulnerable beneficiaries of the charity, or the reputation of that particular charity or the sector as a whole, to be at risk as a result of either activities or inactivity in some cases that's going on within a charity.
Sorry. Yeah, go on, carry on.
Just one final thing, perhaps just to say there, is that whenever we exercise any of our functions or powers, we must always do so in accordance with the principles of best regulatory practice. So, for example, it is set out in the legislation that we must act in a manner that is proportionate, accountable, consistent, transparent, and targeted only at cases where it is needed. So, in other words, any action we take is meant to be a bit like keyhole surgery, if you like. We're meant to kind of like minimize the amount of collateral damage we cause by through the exercise of our powers. It's meant to be a kind of precision tool, not a blunt instrument.
Yeah. Okay. So you don't use a hammer to swat a fly.
No. Well, hopefully not.
Okay. Good stuff. Yeah. So, but I'm going to come to you, Reverend Yemi. Now, apparently from what Steve has said, the bulk actually stops with you. You wear several hats as a trustee. And ultimately you're trying to see that the charity achieves its purpose. Now, the question is, how do you manage the power play that sometimes could occur between yourselves and maybe the CEO or the rest members of the operational team? And how do you manage that in discharging your functions in a way that does not impede on the ultimate objective of the charity? So how do you do that? And how do you effectively delegate without abdicating? Because there's just two ways. So one way, you don't want to be too, how do you manage it? I'll just leave it at that. Yeah. You're on mute right now. Yeah.
Yeah, okay, thanks for the opportunity to be on this with quite more intelligent people than I am. Pardon me, I'm not a legal person. I'm just trying to be ordinary guy. So basically, it depends on different organizations. Some charities, the foundation of the charities really gets a lot of the trustees involved in the day-to-day running, more or less doing the executive role of the organization. And that will have been historical in the way the organization is. So it now depends on when you have new set of trustees trying to change what has been historical over a period of time, which is not actually the right thing to do. For me, I think in most instances, it's about being clear about what is the role of the executive and what is the role of the trustee. I think it's a kind of a relationship where you don't want to be too close and you don't want to be too distant. If you're too close, the line can be blurred. And if you're too distant, you miss the communication. So the executives need to know exactly that they are to deliver all the functions that is there. The recruitment, staffing, vision, and all that sort of things that the executive is supposed to do. The danger comes when the trustee is trying to oversee modern governance by going down into nitty-gritty of what maybe staffing, maybe some of the other things that they don't need to get involved with. But I think it is much clearer if from the onset there is a clarity and the building up more like what is supposed to be the complementary role between the executive and the trustee. That helps and it puts things at check.
Fantastic. Yeah. Yeah. Do you want to go, Paul? You want to?
Sure. I guess, Reverend Femi, thank you very much. I wonder if you could just give your view on from a trustee's perspective, what do you think the single most important role then is? And you've kind of just addressed this, the single most important role of a chief executive officer of a charity.
I think the chief executive officer's role is quite very good, is to deliver the vision of the organization. And part of delivering the vision is also to lead the staffing of the organization, recruitment, discipline, whatever that needs to do, and then be responsible to the charity by submitting whatever the report or whatever it is to let the charity know this is how the organization is running financially or otherwise, to let the trustees know how the charity is going. But I think the danger is always when the chief executive is not strong enough to hold his own position and then allow the trustee to take over. I've been in such situation before, whereby it is the trustee that are running the organization rather than the chief executive, because of the chief executive not being clear about his position to do that. But it's dangerous. It's not a good thing at all, because then they start doing the staffing stuff, employment, recruitment, interview, that they should not be involved at all. But these are the kind of a thing that we need to be clear in terms of the role of the chief executive and the role of the trustee, and which role are complementary, which role are quite far apart. But communication is key in trying to understand each other as they go along.
Well, good stuff, Reverend Yemi, and you just put the spotlight on Elaine now. Elaine is you're CEO of one of the oldest charities, over 200 years old, the Scottish Bible Society. So just a question: do you feel, looking at what Reverend Yemi has said, do you feel like you have to lead the board, or does the board have to lead you?
Well, thanks, Uche. That's a really interesting question. And I would say that one of the most important things in a charity is the dynamic between the board of trustees and the CEO. And in some charities also the other senior staff, but actually usually the buck stops with the CEO. And I would say the answer to your question is yes and yes. So there are times as a CEO that in order for the board of trustees to do their job well, I need to lead them. And that often is around making sure that they have the right information. A board of trustees bring wisdom and objectivity to the governance of a charity. But their wisdom is really only as good as the information that they're given. Personally, I know that I can err on the side of sometimes giving the board more information than they really need. And friends, you need to know that Uche is one of our trustees. So he can either agree or disagree with me as I describe the dynamic between myself and our board at the Scottish Bible Society. But sometimes I maybe give them more information that they need. And then exactly what Yemi has described can happen in that the board, because they're very passionate about the work of the charity, that's why they're involved, they can start to become a little bit micromanagers and want to get slightly too involved with the day-to-day running. But I think that that's a risk that is worth taking. And I think where the relationship is strong and we can be honest about that. And sometimes I'll just quietly say to the board, you know, we're probably erring into micromanagement now, and we maybe just need to step back a little bit. But then on the other side, the board need to lead me because they are entrusted with the vision of the charity and the outworking of the charitable principles. And all the things that Steve has outlined in terms of what the regulator is looking for. And as the governance of the charity, they need to make sure that I am ensuring that we've got all the right things in place. So in that sense, the board are leading me and I am accountable to the board. The board are my employers. And so the dynamic is very much a two-way street. And I think often the health of a charity can be marked by the strength of the relationship and the openness, the integrity and the transparency of the relationship between a CEO and the board.
Thank you, Elaine. I'm going to follow on to that and ask maybe the opposite of the question I posed to Reverend Femi, which is, in your view, from your CEO perspective, what is the single most important duty of a trustee?
I think the single most important duty of a trustee is to understand the purpose of the charity and to support and encourage the CEO in fulfilling the purpose of the charity. So I think things like the induction of new trustees into the charity is an important part of how you ensure that. Making sure that trustees are working together well as a team. We certainly would look for trustees who bring different skills around the table, so that the different areas that we need to take care of, whether it be finance or safeguarding or GDPR, you know, a whole range of things that go into the health of a charity, that the trustee group are working well together as a team. But the primary thing is an understanding and a passion for what the reason the charity exists.
Fantastic. Thanks a lot, Elaine, for that. I'm going to come to you, Gideon, and just following through from what Elaine has said, and hopefully at the end of the day we get a chance for everybody to put their 2 pence in it as well. But Gideon, the most, I often tell my students that the trade in currency in the charity sector is trust. And the trustees are the ones who are supposed to safeguard that, but they usually do it through the various officers within the charity. And the question is, you serve somewhat as like an internal regulator, yeah? And I'll give a typical example before I ask this question. In recent times, we had with what's going on around the world, the sector has suffered a lot, and the resources are really depleting. But interestingly, around the same period, we had the story of Captain Tom, who was able to set out to raise £1,000 and ended up raising over 32 million. And in the same time where there's such a drought in terms of resources, and obviously that you could tie that into, they trusted what he represented, and the public worked with it. So how do you sort of manage this trust amongst the board, particularly where there is a potential conflict of interest with the board members? So how do you manage that relationship amongst the board?
Thank you, Uche. First of all, just want to say it's good to be here. Thank you for inviting me. And I see some of the people I respect so much in the third sector. And I'm really grateful to be here. Moving to your question, it is a fine balance to maintain. I would say that as an in-house, if you like, internal regulator, one of our key functions is the eyes of the board, as well as the eyes of the charity when it comes to minding the gap in regulation or between the regulatory aspects of the activities of the charity and the operational aspects of the charity. So drilling down to managing conflict of interest, that's a big thing for the regulator. A charity's reputation, like you rightly said, is its most valuable asset. And we could see from different scandals how it really depleted the type of donations or donor confidence in this sector. And you rightly mentioned that it's not a lack of willingness in members of the public, but it's basically dealing with, do I trust this charity to deliver on its objectives? And so that makes our role as internal regulators even more important in that regard. And I would say one of the ways we do that is by having a conflict of interest policy. As simple as it sounds, it does serve as a guiding document for the Board of Trustees. Ensure in the induction process, like Elaine was referring to earlier, that the trustees are aware of the conflict of interest policy, what needs to happen, while if there's an apparent conflict of interest or there's a potential conflict of interest. In addition to that is ensuring that as an in-house regulator, you supply the board with adequate information to decide. You sort of like act as their eyes, because sometimes depending on the type of board you deal with, they might be more focused on achieving the vision and the operational side of things. And you as the internal regulator has to be the one bringing the attention or drawing the attention to those areas that potentially could result in conflict and how to manage that conflict of interest.
Well, thank you, Gideon. I mean, just to follow that on, I wonder if you could give a little more detail on the exact functions of I think either both, or is this the same person in an internal solicitor, in-house solicitor, or a company secretary in the operations of a charity? This is to protect or prevent a conflict of interest, is it?
Thank you, Paul. So in addition to what has been said, the role of an internal regulator or in-house legal team, if you like, is similar to that of a company secretary in area of compliance. So in my role, I double as both legal and compliance. And with regards to the compliance element, it would function primarily as a company secretary should function. So that it extends to things like the filing of accounts on time, ensuring that the trustees' annual returns are filed on time, maintaining the statutory registers of the charity, ensuring that the trustees' accounts are also fine. Now, some charities are both trusts and charitable companies, or in the case of some other charities, charitable incorporated organizations, CIOs. And so in my particular instance, we're a charitable company, and that means we have two primary regulators, the Charity Commission of England and Wales, as well as the Companies House. And that means there are certain annual general meetings that need to take place. There's certain reports that need to go in at the year end of 31st of December, depending on what year end that charity operates. Now, the legal side of things is where you then provide some legal advice or guidance, or serve as an interface between your retained external solicitor and the in-house team in providing that robust legal guidance to the board. And I hope that helps to explain that in more detail.
Thank you.
Fantastic. It doesn't seem like an enviable role to have, you know. It seems like a lot of work. Anyways, just carry on from what you're saying. I'm gonna go to Paul Martin. So Paul, you've dealt with a lot of charities. A lot of times when things have escalated beyond the position of in-house, and they've come running to an external solicitor to see if there's some level of solution. I'm going to ask you, sort of fetch for a story. All right. I want you to sort of tell me what's the most, significant, you know, if you could just give it in an anecdotal way, and its most significant problem you've had to deal with in relation to charities, which you think with hindsight could have been resolved if these roles were managed well.
Okay, well, good afternoon. It's a joy to be with you, and that's a good question, Uche. I think the case that comes to mind was a few years ago, where I was asked by the charity regulator in England and Wales to get involved in a charity that had gone badly wrong, and it had an international dimension to it. And the basic facts were these: it was started by an entrepreneurial, very creative person. He established a chain of bookshops that traded very well and were quite profitable. And he decided to really ramp up the reach of his various bookshops and open many more. And he did it by way of investing a lot of charity money in some investments that perhaps, shall we say, weren't regulated. They were in primarily the United States of America, very high risk investments that, if they had come good, would have really, bankrolled the charity for many years. They didn't come good, and a lot of money was lost. And I was asked to go in and sort out the mess, and basically we ended up closing down a lot of the organization. And by the time all the debts were paid, there was not a lot of assets left. Now, that took a year, 18 months of time to sort out. And what I learned from that was that there was no relationship between the chief executive, this entrepreneurial creative person who started the charity, and his board of trustees. And therefore, he was doing various things. And when they came off, they were good. And so the board were happy. But there were no checks and balances. And he made bad investments, he made bad mistakes, and there was no accountability. So when it all came crashing down, the board of trustees was saying to me, we didn't know what was going on. And I said, well, actually, you should have done. Well, we could never meet with him. Well, you should have done, and there was no relationship. And that had meant that the whole thing broke down, and the charity, which could have gone on to do very significant things, was halted in full flow, as it were. And it taught me two things. Firstly, the importance of a board understanding its role. And I would summarize that role under the word governance. They're there to govern the organization. Others have already mentioned in this webinar specific things they do, but it comes under the whole heading of governance. Whereas the chief executive and the senior administration in a charity are very much responsible for the management of it, the day-to-day management of staff, projects, activity, funding, etc. And there needs to be an understanding of the two roles. So the board understand what governance is and keep themselves to that. The management understand what management is and don't get into the governance. And yet, and this is the second point I want to make on this, it's important that there is a good relationship between the board and the chief executive. And I think that is personalized by perhaps the chief executive and the chair of the trustees actually meeting together fairly regularly, just to interact and to build that relationship. Because within a charity, there will be times when the trustees need to say something that the chief executive may not want to hear. And if the relationship has been built and it's a good relationship, then the chief executive or the senior management can hear that the board have their best will at heart, and they're not trying to undermine the management at all. And similarly, the chief executive or the management may need to say something fairly hard to the board. And again, they can hear that if the relationship has been built. And it's not easy to build the relationship, because most boards today are required to have a rotation policy where a board member comes on maybe for 3 years and could rotate off after 3 years. And so you find constantly new people joining the board, experienced people rotating off. And so this relationship is not a one-off establishment. It has to be established year on year because of new people coming in and more experienced people perhaps rotating off. So it's a work in progress. And significant time from management and governance need to be contributed to that.
Yeah, Paul, just before I ask you a follow-on question to that, I'm just going to get the views of Steve on this. Steve, you're from the regulator's viewpoint, and you've sometimes had to intervene when things have gone bad. In relation to what Paul has said, and in terms of trustees and governance, the exec and the rest dealing particularly with management, what do the regulators do to facilitate that cordial relationship? And you know, how do the regulator come in this kind of situation that we just described here?
Well, first of all, I would say that you know, what Paul was saying there resonates absolutely with our experiences. You know, when as a result of our inquiries, you know, charities can go wrong for all kinds of reasons, but a kind of common theme that emerges from that is a breakdown of relationships. A breakdown of trust within the board itself. So we often encounter sort of internal disputes, if you like, some sort of factions of trustees who have fallen out with each other, breakdown of trust between trustees and their funders, breakdown of trust between trustees and their employees. So the you know, I mean, it's probably just worth me saying that, you know, as a you know, our role is as a registrar, a regulator, you know, so we register charities, we regulate charities, and we at times remove charities from the register. We don't run charities, and we don't rescue charities. Ultimately, if charities are in difficulties, you know, we have a regulatory interest in reputation, we have a regulatory interest in the beneficiaries and in the assets of that charity, but ultimately the responsibility for rescuing the charity itself rests with the trustees and with the members of the charity. So our intervention is not with a view necessarily to rescuing the charity. Our intervention is to ensure that charitable assets are protected and continue to be applied for charitable purposes. But what we will be looking for very often is a plan. We will where some sort of dysfunction within a charity has been identified, what we will be looking for is a sort of recognition of that from the trustees, an analysis of what's gone wrong, a commitment and a plan for trying to put it right and to sort of mitigate against a repeat, where the weaknesses were, a plan for fixing them, and then a commitment to sort of addressing an action plan, if you like, for putting those things right. Mm-hmm. And we usually know when we've come to the point where we've concluded an inquiry, when we are satisfied that there is a plan for putting things right. Sometimes we will have what we call a compliance review, when we will open up the case and then sort of 6 months or a year down the line and ask for a progress report, for example. But there are times where we need to take sort of punitive action, which might include sort of removing trustees, suspending trustees, or having them removed by the court to sort of put them out of harm's way, if you like. But by and large, we're not there to be a punitive body at all. We're there to work with trustees on problem solving, which could be signposting them to other sources of support, professional advisors, third sector bodies, etc. Okay. But ultimately, our interest is not to it sometimes comes as a disappointment to the public. I think sometimes the public wouldn't be satisfied unless we had trustees sort of hung, drawn and quartered, but it's not really within our gift to deliver that. Ultimately, it's about charity reputation and the protection of charity assets that is our regulatory interest.
Okay, so before I come back to Paul, because I know, Paul, you have a question for Paul. So before I come back to that, just a quick one to Reverend Yemi and Elaine. So Steve said that it's what they're looking for is a plan, and I'm saying in 30 seconds or less, if you can, what is your tip? What tip do you have to see that relationship between the trustee and the CEO sort of works? Anyone can go first.
Elaine first. Ladies first.
Oh, thanks, Yemi. I agree with Paul Martin that regular meetings between the CEO and the board chair, and where possible, other members of the board, I think is the key, because so much of this depends on relationships. And so anything that contributes to the good working relationships is to be applauded.
Okay.
For me, I think it's important to have an element of trust, which will come, like Ellen has said, through regular communication, and then to be open to be challenged, not to think that I'm the boss, whatever I say goes. To open up, to be challenged. Like I said, not to be too far out, not to engage, and not to be too close to blow the line. Have whatever is going to guide you very clear in writing as you start out, and then don't assume that this is what the board of the chair is thinking, and don't assume this is what the chief executive is thinking, and act on assumption. Always make things very clear. When in doubt, always ask questions.
Okay, great. Thank you very much, Reverend, for me. I have a final question and for Paul Martin, and then I think that will, in a sense, tie things up and also open it up for final comments for everybody. And then if we have time, which I think we might do, for 1 or 2 questions from our audience today. So Paul, I mean, when you spoke about all these roles, and we've had, as we've seen, regulators and in-house and external solicitors and CEOs and trustees join, and I'm surprised and heartened that you all agree with each other for a start. And I'm thinking that in these, there could be conflicts between the roles, and in one role disagreeing with each other, or tension between them, and power grabs or whatever. But so I'm heartened by that point. But I wonder, Paul, if you could describe how, in your view, do all of these roles intersect in law and practice, or how do they and how should they? And I know you've already addressed this in a sense, but how do they and should they all intersect in law and in practice?
Well, it's a long question, big question. Very simply, I think this, one has to respect the fact that certainly trustees are in a lay capacity. They're giving time to be involved. So they've got a finite amount of time that they can devote to the charity. And if they come onto the board and they realise that it's actually a responsibility that's going to take 8 or 9 hours a week, in preparation or input or meetings, the case may be, very soon they'll rotate off because they just haven't got time. So you've got to recognise the fact that trustees have a limited amount of time and maximise what they can do through their gifting in the reasonable amount of time they can devote. So it's well to talk about these things, but we have to manage expectations, that firstly from what the charity can expect from the trustees and vice versa. And so how these roles mesh together depends on the available time. Now, the law sets out lots of responsibilities on trustees, for example. I tend to think that the responsibility on trustees is probably greater than, say, the responsibility on a company director of a normal trading company. And they're very high responsibilities, and you're asking them to ultimately be responsible for the operation of the charity. Now, they're not going to sleep well at night if they think that they've got that on their shoulders, as well as their Monday to Friday job and other responsibilities they've got. So you've got to manage that and help them understand that the time they can put in will actually make a difference if they concentrate on particular areas. And that management need to understand of the charity as well what the trustees can and can't do, and they need to understand how their responsibilities under the trustees will lighten the load for the trustees and will enable the charity to achieve its purpose and its objectives. So understanding the role, that's fine, but understanding the limited amount of time, I think, is very important in building that relationship.
Thank you. Thank you.